having me here. I might be a little nervous. I've never done this before. I guess I come here today with some expertise and experience from a number of perspectives. I'm a mental health therapist specializing in substance abuse with over 17 years of experience in the field. I'm a licensed social worker working with Clinton, Eaton, and Ingham Community Mental Health. And I work primarily with those who are rebuilding their lives from addiction. I work in St. John's as well as the Clinton County Jail. In addition, I'm a pastoral assistant with the local congregation, and I'm also the father of 2 sons and a daughter. So I have a lot of time on the front lines, I guess. I strongly oppose HB4564, which would change Michigan law by requiring judges to start with basically a one-solution-fits-all families presumption of joint custody in child custody disputes. This can be problematic in the majority of custody cases, but particularly dangerous when there is substance abuse, and the often abusive, emotionally neglectful, and irresponsible behaviors that accompany it. Behaviors which are very real, but very difficult to prove in a court of law. In general, joint custody is based on the often mistaken assumption that both parents were equally attentive and responsible before the separation. I've concluded that this legislation does not put the best interest of the children at the forefront of custody decisions. Those who currently abuse substances or suffer from addiction may be able to manipulate the systems to appear more stable than they are, until they have significant recovery behind them and can actually become responsible members of society. This often invisible affliction can cause inescapable harm to families and especially to children. Joint custody already receives special and preferential consideration under Michigan law, I believe. This bill is not in the best interest of the child. It is, unfortunately, in the best interest of a currently substance abusing or less functional parent. And I realize I might have a little bit of a narrow focus, but that is because I do what I do. And so, we must recognize that there are very good reasons for one parent to seek primary physical and legal custody, and that these may also be the very circumstances that led to the end of the relationship in the first place. Unfortunately, even in our current law, these parents are often viewed as suspect for not getting along with the other parent, or labeled codependent and somehow damaged, and are in essence punished for wanting to get out of a bad situation and protecting their children. Given a presumption of joint custody to both parents puts the parent trying to protect the children at a distinct disadvantage. Finally, the real issue is not joint custody in itself. The joint custody should be an option if both parents support it and they're both equally capable of adequately parenting. But it should not be presumed unless otherwise proven, and it should be disallowed if there is current substance abuse or grave dysfunction within the home, until that parent can demonstrate over time significant and positive change. And I thank you and I appreciate your time.
Thank you, Mr. Reitzell. Have you turned in the testimony?
I have it here.
Okay. If you would provide that to us, we'll make copies for the members.
Okay, appreciate that.
Questions from members? Thank you very much. And if you provide that, we'll make copies.
Okay, thank you.